This is Ben Barton, and you're watching the Break It Down show.
I'm live from Palm Desert, taking a little bit of a break, but still working, of course. We've got Ben on the show, and we have Dan co-hosting. It's really great. So Ben has written a book called Credentialed Court, and he talks about the varied past of all of our Supreme Court justices. And this is like a legit, like academic level work. He teaches at a university. So I think you guys are going to enjoy what this is, especially now, since we have the President Joe Biden trying to select the next Supreme Court justice. And I don't want to say anything else because, Ben, I want you to give us what you found with all of these different people and the educations and varied pasts. What patterns have you noticed?
Oh, man. Yeah. So first, thanks for having me. I'm thrilled to be on. Basically, it takes a look at what Supreme Court justices did before they got on the court. And it's got some like fun anecdotes. I mean, these people lived really varied and some pretty bizarre lives. And then it's also got the fancy word is an empirical study. Basically, I started with John Jay, the first guy to join the Supreme Court, and ended with Barrett, the last person to join the Supreme Court at the book, and looked at the trends, like what types of experiences have come to become more common, what types of experiences have come to be less common, what can we learn from the first 100 years on the Supreme Court. And then in particular, I take a special look at the first 10 justices, basically the Washington appointed justices, because insofar as you're an originalist or care about what we used to do, that's a good sign of what the framers thought might be appropriate for the court. The short answer, and I mean, we're going to have a long time to unpack it, but it's changed a lot. And in my opinion, it's changed in sort of unhelpful ways.
Yeah. The unhelpful part seems to me, if you have people coming from, I mean, we love diversity in this country, and even though the court appears to be somewhat more diverse than it used to be, we're largely seeing the same resume played out over and over again. Is that fair to say?
Oh, absolutely, for sure. Well, and I mean, I'll just start with the obvious thing. Like, you just look at a picture of the Supreme Court, this Supreme Court, and then with Biden appointing a African American female, that'll be the most diverse in terms of race and gender Supreme Court ever. And so, if that's the diversity, if that's your lone measure of diversity, we are on an upward trend. There's two different studies. One of them is an actual diversity study where I use a biodiversity measure to see, it's like as if you were in a forest, how many different little critters you have in the forest. And the biodiversity measure of race and gender is hilarious. It's just like completely flatlined all the way into the 1960s. And then it's up, 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 up. So if that's we're certainly making a lot of progress on that front. But other areas of diversity, educational diversity, experiential diversity, where these people grew up, the types of lives they've lived, all of that is weirdly kind of coalescing around a single model of a Supreme Court justice. And this is a completely bipartisan thing. The Obama justices look really similar to the Trump justices, look really similar to the Bush justices. We've settled on this sort of elite educational model. Everybody on the Supreme Court, except for Barrett, has gone to Harvard or Yale Law School. Everybody in the Supreme Court, except for Barrett and Thomas, went to an Ivy League undergraduate institution. So that's a really, really, really similar group of folks in terms of education. Then four of the current 8 justices on the Supreme Court clerked for somebody on the Supreme Court. And it seems likely that Biden's going to appoint another person who clerked for someone on the Supreme Court. And that, for folks who are not sort of in the business, it's the hardest job to get out of law school. It's a really, really, really elite group of people. It's not just that you went to Harvard or Yale. There's hundreds of students who graduate every year who did that. It's that you were at the top of your class. The very best of the best folks do that. And then they went on to these sort of similarly elite jobs. They worked in DC for a big law firm focusing on Supreme Court work, or they worked in the White House. Or they worked on the Senate for one of the committees. These sort of really, really fancy, or a lot of them worked at the Solicitor General's office, so they're arguing in front of the Supreme Court. So you have what I call this sort of elite, hyper-credentialed group of folks. And then the other thing to sort of notice about the sort of collective experiences of them is that they're really cloistered jobs. Everybody except for Kagan, who's on the Supreme Court, has served as a federal appellate judge before they got on the court. And then a bunch of folks have been law professors. And those two jobs are really, really, really cloistered jobs. And I can tell you, I'm a law professor, so I know. You mostly run across other law professors, other lawyers, or law students. And if you know anyone in those groups of people, they're not regular folk. That's a very specialized group. And being a federal judge is even worse. Like a federal judge, and again, there are good reasons why you would keep federal judges cloistered, right? Like you don't want them mixing and matching with people. They don't need to see the actual trials and the folks. Those are good reasons why they make sense to be on the Federal Court of Appeals. That being said, these sorts of experiences mean that you get these people who are only rubbing elbows with the same groups of folks, and you'll get people who have basically lived the same lives from when they were 18 forward. Like this will sound really, really strange, but Sotomayor and Alito have lived almost identical lives from the time that they were 18, despite disagreeing about everything that they saw during that time. They both went to Princeton undergrad. I think they both went to Yale Law School. They both worked as a prosecutor, and then both served as judges before they got on the court. So it's just like amazing similarities between those two.
Yeah, and I mean, we don't know yet who Biden's going to pick, but I know most of the lists list Ketanji Brown Jackson as the top candidate, and this is somebody who, Harvard College, Harvard Law School, currently sits on Harvard's board, and has been has been practicing in D.C. Almost since she left law school, and and has been a federal judge since 2013. So
yeah, no, the three finalists, or the three people you hear the most about, Jackson, and then Kruger, and then Childs. Childs is actually an outlier. She's actually been a state court judge, and she spent the bulk of her career in South Carolina. But Kruger and Jackson are like identical from these other people. They're both super extra mega fancy educational backgrounds, great clerkships, and then mostly practicing in DC. And you just really, really get this cluster. That's another thing that's super interesting in it. I did a geographic study to see where these folks had spent their time before they were on the Supreme Court. And of course, they've like all the Supreme Court's people have spent some time in DC. And in the first Supreme Court, you had John Jay, who had been in DC off and on for years and years and years. So because of government service, you had people who had lived in DC. All of that being said, this Supreme Court has spent more time in Washington, D.C. than any previous Supreme Court, and by a factor of 4 or 5, like just so much. And part of it is Kavanaugh and Gorsuch, who actually lived in Washington, D.C. or the Washington, D.C. area as kids. That kind of racked up the numbers. But again, I think it's fair to count that. Like DC is a little bit like LA, or it's a little bit like New York. It's a company town. It's a special place. And growing up there is very, very dissimilar to growing up in Indiana or California or someplace different.
Yeah, I thought one of the interesting suggestions in your book, which I think would have some real pros and cons, but certainly would take us back in a lot of ways to a prior model of what balance and diversity on the court was thought of, was the idea that you ought to have one, basically the justices ought to come from the, have practiced in the various circuits that they're circuit justices for, rather than just being all concentrated, in a single national system.
Yeah, no. And again, if you're an originalist, that's how we used to do it, for sure, bar none. I mean, there were seats that were sort of associated with the circuits. And when you got rid of one Kentuckian, you replaced them with another Kentuckian or a Tennessean, and that was it. And the folks came from that area, and they'd lived in that area, and they'd practiced in that area. And they did this partially for political reasons. I mean, George Washington appointed somebody from every state in the original colonies until he got to Rhode Island, and he was like, no thanks. But otherwise he followed that route. And so part of it was political. He wanted the people in that state to feel connected to the Supreme Court and know the Supreme Court. But part of it was logistics too. You have this national court that's coming from these very different regions, and Washington and later presidents, all the way in through the, up to the Civil War, basically, there were these seats, and they wanted people from those areas so they got a flavor for the law. They understood the culture of it. So you could bring together a Supreme Court that represented all of these different folks.
When you talk about the diversity of a court, there's not a lot of socioeconomic diversity and that geographic diversity. I mean, we're a complex nation, and we tend to divide our politics almost on rural and urban. I mean, you look at Illinois is a great example, but it's not the only example like that, where Chicago is completely captured by the Democratic point of view, and then the rest of the state, which because it doesn't proportionally represent the population, but the rest of the state is dramatically different or challenged over. So when you look at the socioeconomic part, I mean, I was really fascinated by the recent documentary they did on Justice Thomas.
Oh, amazing, dude. Whether you like his politics or not,
Right.
you cannot, that's an American story that could only be told here. Just like, sorry.
No,
I'll go in a second. But in the book, I use, there's a group of political scientists who have this gigantic database, and they code the justices by their upbringing, like how poor or wealthy they were. And like just abject poverty, I think there's only been 8 justices out of 115 that have come from just pure abject poverty. And Thomas is one of them. And I mean, whoa, like, I mean, he grew up in like rural Georgia, and his first language wasn't English. His first language was
Gullah, I think it is.
Yeah, totally.
It's like some Creole, which you wouldn't even have. Probably most Americans don't really know that there were still, like in the 50s, people who grew up speaking that.
No, for sure, man. And then he desegregated your first African American to go to a private Catholic school in Savannah.
Incredible.
Just absolutely incredible, dude. The things that he overcame.
One of the things he said too was, he's like, I realized that I was disadvantaged because of the color of my skin. And so I said, I'll be damned if I'm going to not get 100% on every test. And he just insisted, and he attributes it to his grandpa, who basically said the same thing. Like, don't let the sun like catch you in bed when it's out. Like he just insisted on getting through this challenge and everything. And it wasn't easy. And there is something to that. There is something to a guy like Truman being president after all of the different experiences he went through. And, now he's seen as a great president. So do we lose something on the court? Or, I mean, because powerful intellect is one thing. Okay, so you're smarter than everybody else, except until you get to that room. And then you're surrounded by clerks that are as smart as anybody else. So at some point, it's not just smarts. You got to balance the scale of some experience, I think.
Oh, that's absolutely my opinion on it. And one of the things that, like the book is about the Supreme Court and about the justices, but there's this broader question about what merit is that I think that really struck me reading the book. We used to have a much, much, much broader version of what merit is. We used to have a really different mix of people on the Supreme Court, and it's not because presidents used to appoint people that they thought were dumb and bad. Like every single president who's tried to do this has tried to appoint the best candidate that they can find. I mean, it seems obvious, but I just want to say it. That being said, these candidates used to be different. Like they used to get people who proved their mettle by being politicians. They used to get people who proved their mettle by this diversity of experience, being in the military, all of the different types of service where you might show that you're an exceptional individual who's worth being on the court. The current version is this really narrow series of hoops. And I just want to make clear, I'm not saying it's easy. And also, I'll just be really honest about it. I'm a law professor. I didn't achieve many of these things. So I'll just be frank about it. That being said, I mean, it's a really, really, really hyper-focused, narrow competition. And does it produce people at the very, very end who are just super extra experts in what I call sort of technical legal argument? Yes, like there's no doubt about that. Is that the only thing that we should have on the Supreme Court? I have a hard no for that. Like, I just feel really confident that that's not the answer to it. And that I'm not saying that there should be nobody who went to Harvard or Yale Law School or has these elite credentials. There's been a Harvard grad, either law school or undergrad on the court. Every single court from the very first one has had somebody from Harvard. So it actually would be a weird anomaly if we didn't have anybody. That being said, we don't have to have everybody. You know what I mean? We can have a mix of folks who bring different skills to it. Some of them will be excellent as this technical legal thing. Some of them will also have accomplished greatness in the legal field outside of these narrow hoops. They used to, like, there's a handful of guys, and these were men, but actually it depends on how you feel about some of the female justices. But they used to just sort of pick like the best lawyer. They're like, oh, this guy's like, I hear this guy's the best lawyer in the United States. Let's put him on. Like, Brandeis is basically that. Where you have a person who's got this long career. We had people who would prove their mettle by being senators. I mean, we had a former president, John Jay, had served as the sort of executive head of the Articles of Confederacy government. So you had people who demonstrated merit across all sorts of different ways.
When you look at all the different, we tend to, when I say the words multivariate, people start to not pay attention anymore. But when you're looking at a multivariate analysis of these people and their bios, how important is gender, race, ethnicity? I mean, is that, other than it looking good in a picture, is that a significant contributor to success?
So this is like an actual complicated empirical question to use the fancy answer to that.
Yes.
There are empirical studies that, so first of all, there's a crap ton of empirical studies that also fit what your knee-jerk reaction to this would be, that broad diversity of experience is really, really, really helpful in decision-making bodies. When you have decision-making bodies that are made up of all experts in the same thing who have all had the same experiences, you get groupthink, you get bad decision-making. They shortcut a lot of things. They don't talk it out, you know what I mean? Because they all basically have the same idea of it. So all of that is true. And then there are studies that show that, they've done these studies on board memberships that have more diversity across race and gender tend to have higher profits. For my money, the answer to this, for my money, the experiential diversity is the key. And obviously being a different gender or being a different race is an experience. So that's great. We should have diversity in that as well. That being said, you can't just focus on that, in my opinion. If you just focus on that, you're really, really, really missing out on this broader, richer vision of diversity. And then also, insofar as you care about it being representative of the country, insofar as you care about people looking at the court and being like, obviously they're all going to be lawyers, so it's not going to be that everyone's going to be like, oh, there's a plumber like me. But there can be people from your area, there can be people who have had your experiences, and that would really help.
Yeah, to play, one of my favorite examples of this, the things the court can miss without sufficient breadth of experience was Clinton versus Jones, where you didn't have at that time on the court I think very few of the justices, if any, at that point in time had practical experience in civil litigation. And you had Justice Stevens writing this opinion saying, well, if we make Bill Clinton sit for a civil deposition, that's not going to be a big imposition on his time. And that was basically a unanimous opinion. Breyer, I think, he only concurred in the judgment, but basically you had 8 members of the court spanning from Ginsburg to Thomas who signed on to that opinion. And it's people who were actual civil litigators in the sexual harassment area would be like, you got to be kidding me, man. This is, but let me play devil's advocate here a little bit, because I do, my view in terms of merit is that I do think that it's crucial to have the technical legal expertise, in the sense, at least, that, what the court does is so much more complex than it used to be in terms of just the volume of statutory law. B, if you're trying to do, say, originalist analyses, you're going to have to do a fair amount of kind of, digging into the past and understanding how to read the sources and all of that. And C, that the job, a big part of the court's job is not just reaching the right decisions, but writing the right opinions, right? Writing opinions that can be properly processed, that are clear on what you've decided and what you haven't, that are persuasive to academics and to your colleagues and all of that. And so I think there is a minimum level of, you just need a certain level of technical competence, maybe in a way that you didn't in 1790s. I just, to put that out there, how do you, from your research into this, respond to that?
Yeah, so first, thanks for that. I love that question. Second, I'll say, and this is a long-term trend, this is basically from the 70s and it bounces up and down, but the court is taking fewer cases, and they're finding there are a bunch of unanimous cases, and that's fine. In the cases that are non-unanimous, those cases are longered and more splintered. And it's the Ramos decision is a recent one. That's just a pretty straightforward question about juries and how many jurors you need to have in a case, and it just hideously split. They can't agree on anything. And the empirical stuff backs what I'm seeing with my own eyeballs, which is that this is the most qualified court that we've ever had, depending on how you look at it. And they're also not very persuasive, and they don't get along great, and they fight a lot, and they write these really, really splintered opinions. And then you're like, oh, well, why would that be? And I make the I align it with a basketball team in the book, where I'm like, there's a whole bunch of basketball teams that have failed because of too much talent, where you have 5 different people on the court who want to shoot at the same time, and you just have a meltdown. And in my opinion, that's what we're seeing here. Like, one of the reasons why you see so much splintering, I mean, you got a 6-3 majority, and they still have a really, really hard time getting all on the same page among the 6. And why would that be? Part of it, in my opinion, is the too clever by half thing. Like, all of them are trying to establish to each other and to the country how smart they are and how much they've thought about it. You get all these extra concurrences and dissents, and you get them agreeing with some parts of the opinions and other parts of non-opinions. And again, when the unanimous cases are fine, but when you're doing it in a non-unanimous case, that's a time when you want the court to speak clearly and sort of with one voice. And when you have all of these concurrences showing off and dunking on each other, it's just not helpful, in my opinion.
And is that something where, I mean, in your view, is that something where we've lost something from not having more politicians on the court?
Absolutely, for sure. In the book, I tell the short version of the much longer version of the making of the Brown versus Board of Ed decision. But that's a miraculous decision. That the court in the 50s was the one that, in my opinion, is most like the court today. The court in the 50s, FDR, wisely or not wisely, had decided that he didn't want former judges. And he didn't want former judges because it was hard to tell what they thought. And you couldn't lock them in enough. It's ironic, given that now we only choose former judges for the opposite reason. So we got a whole bunch of former professors. And he was like, oh, well, these professors, these guys are ideologues. They say with their outside voice what they think. They're not going to go wrong. So by the time FDR was president for a long time. So by the time you get to the 50s, it's almost all FDR appointees. And it's just meltdown city. Like, it's like a faculty meeting. Like, they just can't agree on anything. They're fighting over everything, and everything is, one person trying to prove to another person how much smarter they are than everybody else. This court, to their credit, does seem to get along better than that, sort of on a surface level. But again, I think in some of these split opinions, you can really, really see that effect.
When you look at the modern court and where we're at, we've seen it shift, at least in theory, to the right, as Donald Trump got a chance to nominate a lot of justices who made it through. But we also are recognizing, I think, and this is just, I'm not a lawyer, but there's a whole lot more people, which means there's a whole lot more legal interaction and collisions at lower levels. Is it time, and I'm not saying pack the court, but is it time to create more capacity on the court to hear cases, to get things? And then should there be an external element that says we are going to hear this case? We saw some interesting denials to hear cases associated with the Donald Trump challenges to the election. And I'm not trying to make a political statement here, just for everybody to understand. But when you see someone like Justice Thomas write his response to not taking out a case, like if there wasn't damage before and there's not damage now, when are we ever going to hear this case? And so the reluctance of the court to weigh too far in on some very interesting legal questions. And again, this is not a big steel point, but we have these things to sort out. Do we need external benefits, and do we need more court capacity?
Yeah, so I'll just be super frank. Now we're wandering into my area of basically speculation. I'll say a couple of things, but believe me, I'm a law professor. I love to speculate. My concern is that, and this is a bipartisan concern. Anytime somebody opens their mouth and they're like, what we should do to fix the court? We should do blank. I always want to interrogate what's behind blank. And most of the time, it's because I don't like I don't like their decisions, and I feel like if we remix the deck a little bit, I would get better decisions. That's not a persuasive reason to change the court, in my opinion. And just to be absolutely clear, I consider my book to be completely nonpartisan. This is a problem for Democrats and Republicans.
Agreed.
This model that we settled on it's super fun. Like, I've been working on the research since 2011. When Trump was elected, before he gave the list of the people he was going to appoint, but I was like, oh, all Trump does is rail against elites. He says that elites are useless and can't run anything. And so maybe we'll get somebody crazy. Like maybe he'll put somebody interesting and strange. One of the arguments in the book is make the Supreme Court weird again. Like if there was anybody who I thought was just going to take a flyer on it, it was Trump. And then the irony of it was it turned out to be the opposite. Kavanaugh and Gorsuch are just Kavanaugh, Gorsuch, and Merrick Garland, the last Obama appointee who didn't make it on the court, lived identical lives from they were 18. I mean, just exactly the same sorts of people, same sorts of careers. So that's been crazy to me that this has stayed on. Anyhow, all of that to be said, my concern with changing the court is if what you're changing it for is to try and get the results you want, I'm not interested in that at all. If your change is to try and make it function a little bit better, and so, in my opinion, I mean, obviously, I pitched some changes to the court in the book. Then I am interested in that. But again, I want to hear a neutral reason why you would like that, besides, you know, like the people who are like, oh, we should have 15 people in the court. I'm like, oh, that's weird. Like, you think maybe just all appointed by one guy? That's strange. Like, I wonder why you would think that. Did you think that before? Because I feel like that might be a new opinion.
Yeah. And I want to challenge that a little bit with a follow-up. I am in no way saying pack it for one side or the other, but if we can evaluate the performance of any given thing, I think we could create a value on a judge's performance in terms of their, you know, where they sit in where line. Put them on an array and pick one from each part of the array where they're from, and not have all 15 hear every case. Just have a rotating panel that's randomly selected, and you roll it out there, and judges, you know, 7 whatever, blah 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 blah, although they're all on this case and you are hearing it because my my moderator over here has elected that this one is important, you know, and I don't know if that's a realistic thing, but
oh, dude, not only, I mean, I don't think that's realistic to happen in the US, but that is how the courts run in other countries. I mean,
okay.
so they don't even call it a court, they call it like a tribunal in France. And they don't even have a set number. They just have a group of people, like between 20 and 30, and there's certain people who are always on it. Former presidents, former heads of state are on it. Then there's some other people who are appointed to it. And there's a mix of people who hear things, and they come and go, and they have quorum. So it's not like I don't know if you've been to France. It appears to be a functioning country. It hasn't. They haven't destroyed the country by having the wrong type of Supreme Court. Germany is a little bit like that too. They have several Supreme Courts that do different things. And so it is possible to do it, like, and it's also possible to do it and have a well-functioning country with an operational legal system. That being said, in terms of like amending our constitution, although some of the things you said you could just pass through Congress, I still think there's a great hesitancy to change those things. And on the one hand, doesn't appear to be a super well-functioning institution. On the other hand, there are really, really good reasons to be small c conservative when you're messing around with this sort of stuff. You know what I mean?
One of the big changes over time, you know, it has been the law clerks, because obviously you started off with, you know, for the first century or so of the court's existence, there were no clerks, no law clerks, and you know, I mean, obviously, if you go back to, you know, the 1820s or 1830s, the justices are largely, I think, you know, a lot of them are just sort of reciting their opinions from the bench. I mean, often from a prepared text, but, you know, there's a reporter who's actually typing the thing down, you know, to where you have the changes in the composition of the opinions from modern word processing and such. But you know, talk a little bit about sort of what you looked at in terms of, you know, the clerks and how clerks have changed the court.
Yeah, so it's super interesting. I mean, the first one comes in the mid to late 19th century, and the first clerk is, of course, from Harvard and is hired by a justice from Harvard. And that the first clerk for the first couple of years, he had a clerk who was paying him out of his own pocket until they eventually got money from Congress to pay for it. And then, the growth of the clerks and the work that the clerks do, and then now the craziness of having Gorsuch replace Kennedy. And if Jackson took over, she clerked for Breyer. You would have, not only do you have former Supreme Court clerks, but you have people actually replacing the justice they clerked for, which to me is mind blowing and super incestuous and weird. Like I just don't feel good about that trend at all. And then the clerks, you already have, like, the clerks is this own elite battle to get on there and become the clerks, and then they have their own incentives and effects on the court as they go. I actually think part of the reason why the opinions are longer and why the opinions are worse is because the clerks are involved. I think having the justices just write it themselves would result in much, much, much better work product. And again, it depends what you mean by better. The clerks have the time and the energy to do a massive amount of research and double cite everything. But that being said, if you go back and look at some of the most famous and the best Supreme Court opinions, they're not that long and they're not that well, they're not completely buried alive under citations. I mean, Brown versus Board of Ed is a perfect example of it. It's like a 15-page opinion. It's got, I don't know, 25 citations in the entire thing. And yet it reads cleanly and clearly. And in this fractured court, got a 9-0 vote. Like, it's just a miracle, that opinion.
Well, and the Supreme Court bar has become much more insular too. I mean, even just in the past decade or so, the percentage of cases argued by sort of the handful of, ex-clerks who make a full-time business of appellate law,
For sure.
has gone way up. I mean, I know the firm that I practiced at, like when I was a junior lawyer, it was kind of, you kind of took your own cases up in the appeals courts, and that moved into having a specialized appellate practice where the person who handled a case in the district court was going to have to hand off much more of it at the appellate level.
Yeah, Roberts is a perfect example of this. He's one of the prototype guys who, I don't know, he argued 25 cases before I got on the court, and most of them were on the private side of things. He just got to be a really, really, really successful Supreme Court litigator. Again, folks will be, and there's I don't know, multiple other people on the court who worked in the Solicitor General's office, meaning their actual job was to argue for the government in front of the Supreme Court. Yeah. So one way to read that is like, hooray, look at this. We've got this super qualified group. They actually worked practicing before the court, and then they went on to become Court of Appeals judges. What could be better than all of this experience, this narrow experience focused on this actual thing? And I think they've got that exactly backwards. The Supreme Court is super cloistered. They're already going to have to do this job. Spending all of your time only doing that sort of work just means that your time before you get on the court means you never met anybody and never had any real experiences. The court is already a really, really, really insulated body that does a very specialized area of law. And then doubling down on that by choosing people who have spent their whole lives focusing on that area of the law just strikes me as really backwards. In the book, one of the examples I use is standing law, which I promise I will not try and explain. It would really, really, really hurt the feelings of the people I'm looking at and the people who are listening right now. And the reason why is standing law, and this is a Scalia opinion, and I'm pretty sure Breyer shared it, so this is a bipartisan thing. It's just a mess, a swamp, doesn't make any sense whatsoever. When you are a Supreme Court advocate, you spend a lot of time trying to unravel and figure out standings law. And then these people end up on the court and they think it makes sense. Like that's not good. You want to bring somebody on the court who's like, wait, we're doing what? And why would we be doing that? Like, and so to a certain extent, and this Dan goes back to the complexity point. Part of the complexity comes from the super smart people who are on the court. That's my opinion on it. The decisions have gotten longer and they've gotten more complicated. And the reason why is we have technical legal experts doing it and just overdoing it. At least in my experience, sometimes the best answer to a problem is not to bring the smartest people and experts in the same area all together in one room so that they can create the smartest possible solution that they have to that. Those solutions frequently tend to be super complex, and like you've seen the proliferation of multi-part tests, like all of these things, in my opinion, have come from this over-reliance on a certain type of thinker on the Supreme Court.
What do you think, what does Hammurabi or Solon, what do these guys think of this court if they were to sit down and see, this iteration of what those guys were doing so long ago?
Oh, I love that question. That's great. Yeah, actually, one of the things that I point out in the book, I use the example of Aristotle. So Aristotle thought that the best way to be a judge was to have the non-fancy term is practical wisdom, and the fancy term is phronesis, and that's the Greek term for it. And it's great. Aristotle in his Ethics compares practical wisdom, which he derisively calls mere cleverness, which Aristotle has no time for whatsoever. Practical wisdom can only be gained through experience and is not necessarily a reflection of raw intelligence. And in my opinion, that's what we are just sorely, sorely, sorely lacking on the court. You have these people, and again, I think this is a bipartisan thing, who really reflect mere cleverness with great and alarming frequency and have a hard time getting this sort of broader practical wisdom, experiential take on the law. And again, like people will ask me like, oh, does that mean that we would get a different opinion on particular issues? Like would abortion look different? Would other things look different? And I'm like, no, I can't say that. I don't even know the answer to that. Here's what I think would look different is I think the court would operate better together. I think you would get a humbler court because you would have a group of people who together would be like, well, maybe we should, slow play it a little bit. And again, your mileage will vary with that. 20 years ago, I think conservatives would be like, wow, that would be awesome. We should definitely have a humbler court. And now they're like, hey, maybe less so with that. But for my purposes, that's the argument of the book for sure, is that this diversity of experience and a particular group of people who have had this sort of practical experience would be a much better group to be making these sorts of really groundbreaking, broad decisions.
Yeah, I mean, one of the...
Oh, go ahead, Dan.
No, I was going to say, I mean, one of the things certainly that, fans of Justice Thomas often point to as what you might call a small R Republican virtue is the fact that he spends his time off the court, season, driving around the country in his RV and just hanging out with regular people. And, one of your proposals is to maybe bring that back as a formal part of the justice's job. You talk a little bit about circuit riding and where that fits into the history of the court and why you think you'd like to bring it back.
Yeah, so for the first 50 years of the court, the bulk of the work was what they called riding circuit. And in fact, when they first created the Supreme Court, they created a 6-person body, which I don't know if you know anything about voting, but that's suboptimal to create a 6-person body. So, and I mean, the framers could count 2. So you're like, well, why would they do that? And the answer was there were 3 circuits, and there were going to be 2 justices on each circuit, and that was it. It was like if you asked them, they were like, well, what's going to happen to these split decisions? So like, oh, don't worry about that. The actual court work isn't that big a deal. The main thing is to get out there in the country and do the circuit riding. So yeah, they spent the bulk of their time and the bulk of their mileage traveling all over the country, hearing cases. They had some cases that they heard as direct trials. And again, circuit riding from the first beginning, the justices hated it. John Jay hated it. And the justices from the Southern Circuit in particular were just absolutely miserable. And if you think about it, it's not like if you don't have paved roads and you're riding in carriages, it's a tough get all over South Carolina, starting in Washington, D.C. And there's all these stories of getting bucked by horses, and you had a justice who got stuck in a flood and almost drowned. They're taking canoes to get to Savannah to hear cases. So you can imagine if you're, and these people were all like highly, they'd had a lot of experience. So they were older guys, and they did not enjoy traveling by horseback all over the country. That being said, Congress kept them out on the road all the way through up until the late 19th century because they thought it was really, really important, not only that they came from these places, but that they went back to these places.
Yeah.
One easy way to see what's happening on the ground is to put the people on the ground. Like they heard trials, they heard appeals, they were out there. If somebody had something to tell them about it in Louisville, Kentucky, or in Boston, Massachusetts, they heard it right from the horse's mouth rather than sort of sitting in DC. So part of the pitch of the book is first to bring back geographic diversity by requiring people to actually come from. And again, this is no shade to Neil Gorsuch, but I mean he's named as a justice from Colorado, but he hadn't really been back to Colorado until he became a federal court of appeals judge. Like he had basically been in D.C. that entire time, and he hadn't lived in Colorado before that since I don't know, it's just 14 or 15. And then the second part of it would be, even if you're not going to do that, at least make them ride circuit. Right now, they have a really, really lovely summer vacation. And I feel super bad taking it away from them, but that's my recommendation. Rather than going to teach in Vienna or even Justice Thomas spending his time driving around an RV, they can spend that time. They get paid during that time. They get a paycheck from the federal government. They could go out and visit these circuits. And if it were my money, I would go ahead and have them do trials. I definitely would. They don't need to hear any more appeals. They've got plenty of experience hearing appeals. And especially if all of them are going to come from an appellate court job, 8 of the 9 of them, then you're not going to need for them to do any more of that job. But actually hearing a trial and having to answer evidentiary questions and respond to objections and set bail and do those sorts of things, these folks make decisions that have massive, gargantuan impacts downstream. And it would be really, really nice for them to at least visit downstream. You know what I mean? We used to have, like, there was a justice who had served on a state court all the way through Souter. So from Jay to Souter, every Supreme Court had a justice who had served on a state court. And now we have none. And we haven't had any for 20, 30 years. And that's a big deal. Most Americans will never see the inside of a federal court. And that's actually pretty good news for them, given what federal courts do. But most Americans will find their way through eviction or divorce or child support or adoption inside a state court. The state courts just dwarf the federal court. That being said, the U.S. Supreme Court has a massive effect on the work that those folks do, and it'd be really nice for them to see some of that. You know, just get out and see regular folks and how they experience the judicial system. You're going to spend a lot less time crafting 7-part tests for everything if you get out and see how people actually like sort of live through this.
When you look at all your database of all the judge attributes, you know, and you would say, hey, like this is probably the right kind of judge from this place or whatever it is, and you know, you sit back and you go, Yelnick McWawa, and there's a little Cheers reference for everybody, but who is that person? What does that person's bio look like? The ideal diversified judge, if we're going to find someone to shake up the court a little bit.
Yeah. So first, remember that there's 9 seats, so you don't have to have each one be perfect. You just need a nice blend between them. Second, the first 10 justices are great. Like the Washington justices are just a fascinating group of folks, and that was one of the most fun parts of writing the book. But in the book, I actually pull out 3 justices as examples of what we're missing, and I call the chapter 2 Marshals and a Wizard, because it's John Marshall, Thurgood Marshall, and then Byron Whizzer White. And I actually quote, I think it's Sandy Levinson, who's a law professor at Texas. And one of the things he says about the people who used to be on the Supreme Court is he calls it the hit by a bus test. So if this person got hit by the bus the day that they were about to get appointed to the Supreme Court, would they have been worthy of a biography? Had they done something in their life that was exceptional enough where you would be like, oh, well, the Supreme Court was also interesting, but the things they did beforehand were absolutely amazing. And we used to have huge swaths of folks. Obviously, people who've been senators or presidents or things like that have really, really accomplished a lot. Brandeis is a perfect example. Brandeis would have, like, his biographies are fantastic and super interesting before he ever gets on the court. And then John Marshall, Thurgood Marshall, and Byron Whizzer White. I'll just choose White because his life is really, really, really amazing. He grows up in just abject poverty in Colorado. He lives in a farming town. He swims and plays football. His swimming practice is swimming in the irrigation ditches in the fields. That's where he swims. In Colorado at this time, if you finished first in your class in high school, you got a free ride to go to the University of Colorado. And so he made sure to finish first in his class. He earned a full scholarship, and it was not for football. He gets to the University of Colorado, tries out for the freshman team, barely makes it, doesn't play at all, gets injured his sophomore year, comes back his junior year, just goes absolutely nuts as the quarterback in the single wing. So first, it would be funny that he just did the pass run offense, except there's no passing at all. They just hiked the ball to him and he ran. And he's the punter, and he's the field goal kicker, and he plays safety, and he's the returns the kicks. By his senior year, he finishes second in the Heisman voting. And he brings them to the Cotton Bowl, which is, they didn't have the playoff then, but was the equivalent of the playoff. And they are ahead at halftime based on his picking up, getting a pick six, and returning a kick for a touchdown, and kicking the extra points. Then he goes on to the NFL. He's the highest paid player in the NFL. He's the leading rusher in the NFL for 3 years, at the same time as he's a Rhodes Scholar, and then goes on to Yale Law School. Like, just an absolutely and he led the basketball team to the NIT championship and came in second on that. He's just an absolutely amazing person before he ever got on the court.
And I think his confirmation hearing was like 15 minutes or something.
Oh yeah, no, for sure.
Most of which was people asking him about his football career.
Oh, of course. Yeah, no, for sure. There's if you do a YouTube search for Byron White football highlights, there's like a 20-year-old 20-year-old documentary that they did that has the old black and white stuff on it, and it's laugh out loud funny. I mean, he's just a hot knife through butter. It's just like him running with people shedding away from him, like as if he's got the reverse magnetism. It's incredible.
As we look at like our criminal justice system, we're trying to sort these things out, and the law is part of the problem. There's a case I know specifically where the victim who was murdered has DNA under her fingernails, and there's a question as to the guy who's in jail and if whether or not that person did it or not. But the way the law is structured, unless something changes, that person who could be innocent. I mean, there's evidence right there. We can't, so it's DNA evidence. You can test it all over the place. We know for sure that we've put innocent people to death on the death penalty. And so these are things where, I mean, if you're standing and looking at the government and you didn't do it, it's really, really hard to prove otherwise because the government has all the resources. It seems like judges, Supreme Court justices would need to ride on that part of the circuit to look at some criminal cases to get an idea of what's happening because, as much as they know about the law, how much, like you're saying, how much do they know about life and where it's at right now? We see it all the time where DAs and the senior cop in the area do things that are less than honorable and put innocent people at risk, ruin their lives regardless. Is there a penal aspect that the judges need to get more hands-on with so they can realize just how challenging that environment is?
Oh yeah, for sure. And in particular, one thing that's been really, really noticed, we've had a criminal procedure revolution from the 60s forward, and you've had a lot of rights created, and this is to better or worse, depending on how you feel about it. Here's one thing that I will note that is clearly worse, in my opinion. You have a better protected right to a free lawyer than you do to a jury. And you're like, well, that's weird because the right to a jury is both in the Constitution and in the Bill of Rights. And if you've read anything the framers had to say, the number one thing that they cared about was a right to a jury. They just wanted your peers to be there. That was the main check on government authority in the criminal area, was going to be the jury. And yet the jury is sort of dried up on the vine. I mean, basically you have to look like you're going to serve 6 months or more in jail before you can get a jury, and you get a lawyer if you're going to serve any time in jail at all. And there's no guaranteed right to a free lawyer in the Constitution. They've kind of worked it out through the Due Process Clause, but there's clearly a right to the jury. And if you ask yourself, well, why would they protect the right to a lawyer more than a jury? It's because first, they've really, really, really prioritized plea bargaining, and plea bargaining is a huge part of this problem. That's a greased skid into jail for sure. And if you're not going to take the plea, you're looking at much, much, much more significant punishment. And that's a significant impingement on your right to actually fight charges against the government. And second, everybody who's a justice on the Supreme Court, one thing that they know for sure is what it's like to be a lawyer. They're like, oh, you really need a lawyer? That was my experience when I was a lawyer, is that everyone needs a lawyer. And then if they sat through a jury trial, they're like, well, I didn't like those 12 people. It was kind of squirrely. Like, you brought people off the street and they were making decisions. I feel like we should more lean into the lawyer part of it. Yeah. So I think it's a perfect example where your experience in the system and how you see it. And again, historically, a bunch of the practice, especially the criminal practices, come from being a prosecutor. And this is not true of every prosecutor, but most prosecutors consider the plea bargaining part of the system to be the system. I mean, that's the whole point of it, is to get people to plead guilty. The more, if you're having a bunch of trials as a prosecutor, most folks think you're not doing it right.
Yeah, and I mean, because most people who make the Supreme Court have, gone to law school fairly early on. If you are, I mean, like I went, if you're like me, if you went straight from college to law school, the odds are that you've never served on a jury, right? I mean, they've never put me in the room, I think most people with Supreme Court backgrounds have probably never been a juror.
Well, and a bunch of them have had no experience of a jury trial whatsoever. The only person who's been a district court judge right now in the court is Sotomayor. Everybody else has only served in the Court of Appeals. And then the practice experience that they have, the prosecutors, Sotomayor and Alito were prosecutors, so it does seem likely that they had some jury trials. Everybody else, I mean, if you're Roberts has got the most practical experience on the court. He's got, I don't know, 12 or 13 years in private practice, working at a big fancy law firm, doing Court of Appeals stuff and doing Supreme Court stuff. He's never, like, there's 0% chance that he's had a jury trial, like just none. And his experience of a jury trial at best would be to read the transcripts and see what was said at it. But that is not the experience of seeing those 12 people come in and make the decisions. That's a really, really unique. I mean, that's like, if you were going to praise some part of our justice system and something that we exported, that was it. And so it's, in my opinion, it's just a shame to see it, downgraded. It's maybe a little harsh, but less respected.
I want to go back to the criminal penal system part of it. You may have a public defender assigned to you, but that person's also a lot of other person's lawyer. And there's a big problem with those folks. Look, they're all doing the best they can. And a lot of that work's contracted out because there's such a lack of capacity. And so I would think as a judge, you'd see that and be like, how in the world does this person there's a chain of evidence, like, don't call me, only email me. Then you email and then you don't get a response for 2 minutes. I know people that have had public defenders, and it is a system, but boy, as a judge, I'd want to know that and be like, why is this person even still in court? Like, if they have terrible representation provided by the state. So, I mean, how do you educate yourself if you are in this Harvard, Yale path? How do you ever even have an understanding? You're a great lawyer, but do you know, like, the nit and the grit of the system and how much it does imperil people's, well, I mean, sometimes you can be like, I'm completely innocent of this, but the best thing is for me to take this 6-month suspended sentence, pay a fine that I can't afford, and go on about my business. And now I'm hobbled in some way for at least the next few years, if not permanently, because I don't have the means, and the system lacks the ability to give me the means to get through this. As a judge, I'd want to know that stuff.
Oh, yeah, for sure. And insofar as you care about that, I will note, I mean, the Biden appointees in the lower courts, and if he decided to appoint Jackson, he's got a lot more people who have got criminal defense experience than is typical. And one of the things that's ironic about it is the original Washington justice, a big chunk of those guys had criminal defense experience because they were basically solo practitioners. I mean, John Jay and Alexander Hamilton didn't end up on the court, but like these are guys who made a living as lawyers in the 18th century. And when you did that, you took whatever came in the door, up to and including jury trials. So you like, it's funny to think about it, that you would lose that experience. But we, in fact, when you lost the private practice of law, that was one of the experiences that we lost. And the other thing that I always remind the students when we go through the Bill of Rights and we go through all of the rights of criminal defendants, I'm like, well, why do you think that the framers might have cared about that so much? And they're like, oh, maybe they were big-hearted people. I was like, oh, no, because they were rebels. And if they lost, they were all getting hung. Everybody was getting hung. So believe me, it was fresh on their mind, like how they would have been treated under the previous system.
Yeah, I mean, Hamilton defended murder trials. I mean,
Oh,
I
yeah,
think
he did
yeah, I mean, Adams, of course, defended the Boston Massacre case. So, I mean, you had guys who had really been in court with somebody's life on the line there. And
for sure. And John Jay is a lawyer of the similar caliber, like just among, and again, like, it's not true. Well, actually, it's kind of true. One of the things that Washington did is he just went state to state and picked the best lawyer in that state. And he was like, oh, who's the best lawyer in South Carolina? Oh, let's point that guy. Like, who's the best lawyer in North Carolina, and on and on. And that's not a bad way to do it. And again, all of these guys, if you served as a lawyer during that time, and John Marshall's a perfect example of this, you did jury trials of all kinds. You did everything. You wrote wills, you probated, and then you wrote contracts, and then you also took a whole bunch of litigation cases.
Going through the book, there's so many little mini biographies of all these justices. Who stood out where you're just like, no idea how incredible this person was, and what other anomalies would you pick out from the book, or maybe it didn't make it into the book?
Oh, yeah. So one of my favorite guys is Joseph Bradley. So Joseph Bradley grows up in New York State, super rural, poor as hell. He's the oldest son. I think there's maybe 3 or 4 other kids, and he's self-taught. He's going to this Dutch Reform church where he gets some tutoring in the Dutch Reform church. He gets the attention of the preacher, and the preacher's like, we should send you on to college. And so I've gotten you admitted to Rutgers College in New Jersey. So he goes to his dad and he says, this is not the life for me. I really, really, really need to do this. And he's like, son, we can't afford it. There's nothing we can do here. And so Bradley says, well, I'll tell you what, I'll work one more year. And if at the end of it, I'm going to convince you that it's right. So he just busts his ass. They have a great year. The dad's like, your brothers are now old enough, you can go. He goes, studies, finishes first in his class, undergrad, goes on to law school, and then he becomes a railroad lawyer. So and you can imagine being a railroad lawyer in the mid-19th century was quite lucrative. And so he's a specialist in this. He argues, 7 or 8 different cases at the Supreme Court in railroad law. He's a self-taught autodidact, and he's a math expert. He was a math major as an undergraduate. So he gets really, really interested in insurance. So not only is he the nation's leading railroad lawyer, he becomes the head actuarial person for Prudential Insurance, where he's not working as a lawyer at all. He's actually doing their actuarial tables at the same time as he's serving as a railroad lawyer. And then eventually he gets picked because he's the best lawyer in America. They're like, oh, who should we have? Oh, we'll have this Joseph Bradley guy. And those were his 2 jobs, lawyer and actuarial, before he got on the court. And then, as you can imagine, he's a really helpful guy to have on the Supreme Court. He knew, obviously, I heard a bunch of railroad cases going forward from that, but he had the type of brain that really brought something extra to the court.
That's great. Dan, any last questions?
One thing that does strike me too, that we do have a court. We do have justices that stay on a very long time.
Yes.
And I almost feel like with Breyer stepping down, there is an opportunity maybe to rethink that, because for the first time in a very long time, if we started trying to say, how do we get people over 80 off the court? We don't have any of those. Thomas is, I think, 73 or something. Is the length of the tenure that the justices serve on the court a problem as well, in terms of limiting the kinds of people who are on the court?
Oh, I think so, for sure. Absolutely. And again, that strikes me as a more value neutral, like just saying, as an actuarial matter, these folks live a lot longer than they used to. And that's partially medicine. But actually, the studies show that basically being a life tenured Court of Appeals judge, whether you're on the Supreme Court or just a regular federal judge, you live a long time. It's a pretty awesome job. And it's not you're not lifting anything. You know what I mean? It's not a physically taxing job. So people will last for a long time. That being said, and sometimes they last beyond sort of the sell-by date. Breyer struck me as still pretty sharp down the stretch. But that has not been the case for everybody, and I won't name names, but that has not been the case for everybody who's stayed on for a while. So yeah, no, I would think that would definitely be part of it. And also a more set rotation would in and of itself encourage diversity.
The President Biden says, you know what, I've changed my mind. Get me Barton. And you get nominated. What kind of judge would you be?
Well, the good news is that's never going to happen. So we're not going to have to find out at all. Yeah, no, I've taken a little bit of a winding path, not as winding a path as some of the folks who actually made it on the court. But yeah, no, my sincere effort would be to try and make everything much simpler and clearer. Now, obviously, that's easier said than done. And there are areas where it's easy to say it should be simple, but in fact, it has to be complicated. That's not everything the Supreme Court does. And believe me, not everything that's complex up there is complex because it has to be. And so that would be my first thing and my last thing. Every day I would wake up and be like, how can we make this easier and clearer for people downstream?
I love it. Easier and clearer. That's great. And then Dan, same question to you. You're sort of a lawyer of sorts these days, not much more, but what would you do?
Yeah, in some ways I would have a similar answer. I mean, one of the things I've written, I was a big fan, of course, of Scalia, as my readers know, and Scalia and Thomas, but Scalia in particular, I think one thing that he brought to the court, in addition to kind of the legal chops, was this kind of political philosophy of, sort of an understanding of how the law is made, and an understanding of how the dangers of undue complexity. And so he was often a critic of, not only of the multi-part tests, of, using legislative history, because one of the complaints about legislative history was that, it sends lawyers, it creates this specialized field of reading the legislative history instead of reading the law itself. And so he had a multi-pronged attack over the years on undue complexity in the law, things that would generate too much litigation, things that required too much guesswork. So I think I actually would agree with that a big part of what the court, I think there are philosophical questions of judicial philosophy, of legitimacy of law, that are a big part of the conservative critique and all, originalism. But I think there is a lot to be said for the practical critique of the court needs to understand not only how law is made and how it comes to the court, but how the court's decisions operate out in the real world. That you have to have some sense of, how to explain the law in a way that is understandable by not only judges but practitioners. That people can more easily comply with it. That the law can be explained to juries when they're being charged. That the law can be explained to cops who need to know what the procedural rights are. And so there's so many different fields of law. And look, there are plenty of areas of law where the court, comes into over and over again, but there are also plenty of areas of law where the court sort of shows up, writes an opinion, and then walks away from it for 20 years. And often there is enormous amounts of havoc created among the practitioners in some narrow area of the law. And believe me, I've fallen down some of those cracks in my time practicing, where you're just, all these disputes are created because the court used some offhand language that it didn't explain and didn't understand.
Yeah. Complexity, right? Less complexity. I like it. Well, listen, everybody should get Credentialed Court. There's a link there. It's also it'll be in the show notes. Thank you so much, Ben, for coming on the show.
Oh, my pleasure. Thanks. This was a tremendous conversation. I really enjoyed it.
Yeah, and Dan, of course, everybody can find him. National Review. That's where he does his day work, and always interesting. We didn't get to talk about baseball. There was a possibility that we would get into some Mets discussion, but we'll do that some other time. And then just in general, if you guys
let me just say though, Dan, did you hear that? I'm well aware of your Twitter presence. That's because my best friend at law school is a huge Mets fan, and he's just pressing you on me. I just get your Mets content every day.
Well, we can all hope that there will be baseball on time. So
yeah,
that's the real goal for this year.
Yeah, we'll see what happens with that. Those guys are so far apart. And then I also want to mention, you saw Brad making comments in the show, everybody. Brad is going to be the host for our comedy event on Thursday, Save the Brave Comedy for a Cause. Plug in that. If you're in Temecula, come out, hang out with us. Lana Turner is the feature, and Bill Dawes is going to be the headliner. So if you guys want to come out and support Comedy for a Cause, that would be great. All right, stand by, fellas. Hey, thanks for watching the show. I really appreciate it. Right here, you can subscribe. Please do that. It makes the show grow. Hit that notification bell so you know which incredible guest is coming up next. Down below is the PayPal link. You can put a small subscription in. That is an enormous help. All that money goes right back into the show. And then right up over here are the next episodes you should listen to, curated by yours truly. Thank you.